Hi, I'm Jeff Saylor, and welcome to this edition of the A&A Alert. Today I have some great news about the new lease standard. No, they're not giving an exception to not apply the standard for private companies. Oh! But there is good news. On Wednesday, February 15th, the FASB board did approve an update which will solve some major issues for many companies out there. There's two topics that are related to common control arrangements which are covered in this update. First, terms and conditions to be considered in a lease, and second, accounting for leasehold improvements. These issues came up during post-implementation with feedback primarily from private companies. While these are technically not yet an update, the board has advised the staff to draft a final for a vote, and it's expected to pass. So we can pretty much count on these. So let's jump right into them. First one I want to talk about is terms and conditions to be considered. Topic 842, which is the new lease standard, requires entities to determine the existence of a lease based on the, quote, legally enforceable terms and conditions of the arrangement. This applies to everybody, including related parties, including those under common control. Now, why is this so important? Well, because it determines whether or not a lease exists. Now, what does that mean to you? Oh, yeah, it determines whether you have to capitalize it or not. So it's a pretty big deal. Common control is a term in this context much broader for private companies than, say, the SEC would apply to its entities. Okay, we've got very specific things in the SEC realm, but here the FASB has made it very clear it can involve all types of common control scenarios. Say perhaps an entity that was owned by a grandparent and another entity that's owned by a grandchild. That kind of scenario would still be a common control arrangement. Now, under the old rules, topic 840, the concept for determining a lease was what we called economic substance. But under 842, the concept for determining a lease is legal enforceability, two totally different things. For a common control arrangement, determining legally enforceable terms can be difficult even if those terms are in writing. Think about this. Common owners can, amend the terms of the various contracts at will or simply choose not to enforce certain items when they feel like it. That's the nature of those things. Thus, the common control poses issues related to what is actually legally enforceable. These are often not negotiated at arm's length. Duh. Thus, they don't align with other arrangements that might be out there. In addition, the arrangements may be unwritten or lack sufficient detail in the first place. For instance, there might not be any renewal options addressed, even though we all know that there's going to be one in there. Now, due to these factors, private companies were afraid that a legal opinion, actually going out and paying an attorney to figure this out, would be required to determine whether or not a lease existed. And of course, that's going to create all kinds of undue burden, cost, and everything else. So, what did the FASB do in the way of a practical expedient? Well, before we jump into that, who is affected? Who gets this? Well, the practical expedient will be available to private companies and most not-for-profit entities with arrangements under common control. Now, it's not going to be allowed for public business entities, nor for not-for-profit conduit bond obligors, nor any employee benefit plans that file with the SEC. Too heavy duty there. And it will not apply to other related party arrangements, just the common control ones. So what did they do? The board decided to provide a practical expedient which could be applied on an arrangement by arrangement basis. Simply put, an entity may use the written terms and conditions of a common control arrangement to determine two issues. Number one, does a lease exist? And number two, what is the proper classification of the lease? In other words, you don't have to extrapolate. You don't have to go out there and say, what did they really mean? Well, what's really going to happen? No, whatever is there is what we go with. Now, if no written terms exist, then the expedient may not be used and an entity must determine the legally enforceable terms and conditions. So for those of you with the doctor leasing to the practice and that kind of scenario, you might want to get something written up to cover yourself on that. So for transition, if you adopt the practical expedient in conjunction with the adoption of 842, in other words, when you actually put in the new lease standard, then you must use the same transition method that you elected for 842. Otherwise, you may adopt either of these two items. First, prospectively to all arrangements that commence after the adoption of the standard, or retrospectively to the beginning of the earliest period presented. Effective date for this is effective for all entities with fiscal years beginning after December 15th of 2023, including interim periods within. And of course, early adoption is allowed. So if you are implementing leases right now for 2022, then in fact, you can put this in place. The second issue is accounting for leasehold improvements associated with common control leases. Leasehold improvements are improvements made by the lessee to the underlying leased asset. You're leasing a building and you fix it up. They're recognized on the lessee's balance sheet only when a lease exists. I mean, if you go fixing up things in somebody else's property, now you can see why that's not really your asset now, is it? Topic 842 requires these leasehold improvements to be amortized over the shorter of the useful life of the improvements or the lease term, which seems reasonable in most cases. But many common control lease arrangements have a short term, maybe 1 year. That's not uncommon at all. And so a concern was that under the new guidance, improvements would be required to be amortized over a much shorter period than their actual economic life, and obviously that would not result in a faithful representation at all. So the board felt that leasehold improvements with common control leases are economically different from other arrangements not under common control. And I think that's a pretty good conclusion there. Improvements are often made at the direction of the common owners, and that's very, very different. So what's the change here? Well, first, who's affected? This amendment would apply to all lessees who are in a lease under a common control arrangement where the lessee is the owner of the leasehold improvements. Now, this would include public entities, private entities, and not-for-profit entities. So this is not just limited to the private arena. For all leases under common control, leasehold improvements will be amortized over the useful life of the improvement to the common control group as long as the lessee controls the use of the underlying asset through a lease. If the lessor obtained the underlying asset through a lease with another party who was not under the common control, then the amortization period may not exceed the term with the lessor's lease with the other entity. When the lessee no longer controls the use of the underlying asset, they move out per se, the residual amount of the improvements will be accounted for as a transfer between common entities through an adjustment to equity, or in the case of not-for-profits, to net assets. And they do point out that impairment guidance will still remain in place, and you'll have to deal with that if that comes up. Transition. If you adopt this amendment in conjunction with the adoption of 842, then you may use the same transition method elected for 842 or any of the options that I'm going to list next. Now for others, one of these three may be used. You can do it prospectively to all new improvements after the first date of application, prospectively to all new and existing improvements recognized after the first date of application. Now for existing, you would amortize that over the useful life determined at that date. And lastly, retrospectively to the beginning of the first period of adoption of 842 for improvements existing at that date. Effective date here, effective for all entities for fiscal years beginning after December 15th of 2023, including the interim periods, and early adoption is allowed. That wraps up our A&A alert. If you need any help with leases or simply need some engaging and entertaining A&A CPE on a variety of topics, please check out my numerous webcasts at westerncpe.com. Or come see me at a live event this year. Thanks for watching.